Well,
Okay, it's all yours.
so the title that you see on the slide says Plan for the Unexpected. I would say that's a bit misleading. What we usually say is much blunter, which is that we describe the documents I'm going to be talking about as end of life documents, which is not that unexpected. It's just a matter of when. But you don't have to wait. Um, until you're over 60 to do any of these documents. I mean, there may not be much of a point in doing powers of attorney when you turn 18, but I always encourage folk, get a will done as soon as you possibly can. You can always revise it. And that does go for powers of attorney documents as well. So there are four main documents that I will be discussing. But let me say first about LSNV. We provide free legal services in a variety of areas, not just in elder law, to people who are above 60 under Title III federal fundings, also to lower income folk based on federal measures set for income. Uh, our procedure is that you first get in touch with our intake, which you can do either online or by calling us, and I'll give you the number, or by coming in on Wednesdays. We used to be open, I think every day of the week, I'm told. But since the pandemic, all our offices in Northern Virginia, and we're scattered throughout the counties in Northern Virginia, all of our offices have walk-in Wednesdays. So you start with an intake, which determines your eligibility, and then you would end up talking, if you're in Arlington, probably to me, but it depends on the issue that you're dealing with. Um, but let me get right to the documents, if I can figure out how this works. Let's see. Gary, do you know? I think there we are. I don't know much
Yep,
about, there we are, tech either. All right. Can everyone see the slide, last will and testament?
yep.
All right. You don't need to have a will. Every state has its own laws of probate, which determine how a person's belongings in a state is distributed or handled upon the person's death. And when I say estate, I don't mean land, a large piece of property. I mean everything that you own. So the state's laws will kick in if you don't have a will, and they are pretty much what you would expect. Surviving spouses have to be taken care of first, and then the law determines how an inheritance would be distributed among, say, children. Um, Also determines how a body would be disposed of or buried. The advantage of a will is that you get to determine all these things. So long as they are consistent with the law, you get to put in the details. I've had clients who've wanted wills who have almost no belongings, but they wanted to stipulate that they wish to be cremated, which is not what the state law would default to. So they write up a will just to have that established. So it includes disposal body to be, I guess, crude, but accurate plans, as well as the disposal of your property. So a will doesn't have to be registered with the county. It can be. The main thing is that you will appoint an executor when you draft a will. An executor is like an agent, and we'll be discussing that further on. The executor will oversee the adjudication of the will. So the will is still heard in probate court. The court is involved, but the executor shepherds the will through. So while you don't need to register a will with the county, certainly your executor should have a copy of the will. You don't have to give a copy of the will to anyone else. In fact, I kind of recommend against it. So as you see here, will disposes of property after death, states burial preferences, names the executor. You can name a guardian for minor or disabled children if that is pertinent. Keep in mind that the court's guardianship is also a legal matter, and the court will always, in the end, determine whether guardianship will be granted, and if so, who will have guardianship. But you can put in your recommendation in your will. How is it created? You are the testator or testatrix if you're female. You have to be over 18 and mentally competent. You will need two witnesses. You don't even need to know them particularly. They are there just to witness the process of your signing. I notarize the wills that I draft, which means I cannot be the witness or a witness. If you come to our office, we will try to have staff on hand to provide sufficient number of witnesses, but you can also bring in people of your own. I can also go out and visit people. It's easier if you are witnesses when I go visit you than if I have to find someone and drive with them. But you need two witnesses. The executor is also not suitable as a witness, just so you know. We will talk about when you come to me as a client, we will talk about what you want in your will. There are legal restrictions, but for the most part, it's a pretty liberal document. I mean, you can add clauses as you wish, and we will draft the will according to your preferences. Signed in front of two disinterested witnesses. As they say, it can be family. It's maybe not ideal, at least not ideal to have someone who is an heir in the witness, but you can. Um, to whom may I leave my property? Pretty much anybody you want to. And as will see, you also can choose not to leave your property to people you would rather not, with the exception of a spouse, where the law does expect you to take care of your spouse. Any person or organization you wish. Relative, friend, charitable organization could be an institution outside the country. If it's an organization, we always suggest that you get in touch with the organization just to make sure they have a means of dealing with the inheritance that they're going to be getting. You don't need to do that with relatives or friends. As you see, if you're married at the time of your death, your surviving spouse may be entitled to a portion of your estate. You can't, if you have a surviving spouse, you can't just excise the spouse from your will. You can give away, as it says here, property that is owned by you, your property. Money, cars, jewelry, clothes, books, whatever you want, any tchotchkes that you want. Real property, including land and your house or your condominium. Probate property includes any property you own at the time. Non-probate property, property that you can't simply designate in a will, is property that's co-owned or property where you already have a named beneficiary. If you have an insurance policy and you haven't named the beneficiaries in your insurance policy, that would be considered probatable property. If you have an insurance policy that names a beneficiary, that process then runs separately from the probating of your will. Your executor doesn't necessarily have a difficult job, but you do want someone who agrees to do the job and who's reliable and sensible. The executor, as I say, will take the will to court. So this is a legal process. It's not that the executor is acting on his or her own, but the executor has to act in compliance with what the court orders. The executor notifies all the beneficiaries in the will, and the executor has to take care of any outstanding debts or other financial obligations you have when you die out of your estate, not out of the executor's funds. The executor, in a sense, is an agent. So everything you read here about executor having a fiduciary duty, it's the same and that would apply to an agent. And we're going to get to the importance of agency with other documents. Executor has to be over 18 and competent, can be anyone, If you have an executor who's from out of state, there may be a higher bond that the executor has to post to get the executor would get the money back, but the point of the bond is just to ensure that the executor keeps to the executor's duties. Again, if you don't name an executor but you have a will, the court will appoint an administrator. I I have to say I don't do a will unless you have an executor. It really doesn't make sense. I do recommend that you have a co-executor or a secondary executor, a backup if your first executor is not available. What do you do with it? You keep the will in a safe place. You let people know where they can find it. As they say, you don't need to distribute the will beforehand to your heirs. The will is your business, but certainly your executor should have a copy or know where to find a copy. You can also leave one with your bank if you want. Make sure that the executor, however, has access to your bank safety deposit box. If the executor can't get to the copy of the will and it's in the safe deposit box, that's a problem. Yes, you can file your will with the clerk of the circuit court for a small fee. You can do that in Arlington, for example. As we reviewed earlier, if you don't have a will, Virginia law will determine how your property is distributed. Intestate succession means the rules of family succession. Closest relatives, your spouse, children, the state would allot them whatever you have in your estate according to the number of children that you have. Your property goes to the state if you have no surviving relatives and you don't have a will. Clearly, if you have a will, then you determine where your property goes. And this is all if you don't have a will. So before I get into power of attorney, let me just say, excuse me, we have templates for the foreign main documents that we draft. Whenever I work with a client, I show the templates to the client after our first meeting and say, read them over. They're pretty dull and they're somewhat technical. And some of them have optional language, which can get confusing. What I encourage is simply you get acquainted with what the document is about, so that when we sit down for our next meeting and we start going through what you want, you have some idea what already how to proceed through the document and what the document does. Powers of attorney, there are two different kinds that we draft, and they're actually quite different. And again, you can give someone power of attorney regardless of how old you are, if you're over 18 and mentally competent. If you are not competent, and you have been determined not to be competent by a physician and a second physician or psychologist, that's a whole different ballgame. Then we're talking about guardianship. We don't need to get into that now, but it does come up. You can only grant power of attorney if you're competent. So the vocabulary changes. With wills, we talked about you being the testator or testatrix, and your agent is the executor or executrix. With powers of attorney, similar concepts, just a different vocabulary. You are the principal, and you have an agent. It's a written document that authorizes it, as it says here, one person to act on behalf of another, that is, to be the agent. We'll go into some detail about the two different types of power of attorney, but the first one is general durable power of attorney. And that's for financial matters. And it goes into effect typically as soon as you sign it. As you'll see, you can have something called a springing general durable power of attorney, which doesn't go into effect until a certain date or event. Pretty much everyone I've worked with has just had one that immediately goes into effect. There are limited powers of attorney. If you want an agent just to have the power to do certain acts, but you otherwise don't wish to have an agent who handles your financial matters, you can have a limited power of attorney. This final clause is one I stress all the time. You, as the principal, remain in charge. Your agent acts either under your explicit directions for a particular act or under your directions for particular types of acts. Maybe your agent deposits money every month in your bank. You don't need to tell your agent to do it every time, but your agent is doing what you, the principal, told the agent to do. Finally, your agent acts on your behalf sometimes without your giving particular directions if the agent knows in general what you want and you can counter what your agent is presuming to do. And that's to be stressed. You do not give up your fundamental power of attorney when you grant it to an agent. Your agent is acting in your interests and may act only in your interests as your agent. How do I get one? What we mean by one is a power of attorney document. We don't mean an agent. An agent, again, is like an executor. You can pick anyone you want to be your agent who's competent and over 18. You sign a power of attorney in front of a notary. Again, if you're working with me, I'd be your notary. You only need one witness. You don't need two. The witness should not be the agent or can't be the agent. And as I always stress to people, there are certain criteria you need for an agent. The person needs to be responsible and responsive. We often tell people, and you'll see this shortly in the slides, that you might want to have a secondary agent who acts only if the primary agent happens not to be available at the particular time. It's not a matter of co-agents, it's a matter of agents in succession. So not a bad idea to have two agents, maybe even three, but your document makes clear which agent has primacy, and then when the other agent kicks in, that is, if the primary agent is unavailable. Yes, same with a will. You want to work with a lawyer just to make sure, above all, that you are doing a thorough document, thorough power of attorney, and that it conforms to the laws of Virginia. Private attorneys charge a fee, and it typically is a small fee for doing a power of attorney. We charge no fee at all. And I'll get to advanced directives later on. That's the fourth type of document we do. All right. Your agent has to be 18 years old or more, has to be competent, but I stress above all, someone you trust. Someone you trust to be available to act for you, not just who shows good judgment or who's honest, but someone you can rely on. Good idea to have more than one agent. Here it says you can have co-agents. Think it probably is a little less chaotic if you have a successor agent. Be sure to discuss your power of attorney with the person you name as your agent. I always tell us the story about my aunt in California, who named her son to be her agent. Her son is not particularly, well, he's mentally competent, but he's unreliable. He's actually kind of booking to be a felon, if he could possibly. That's his dream job, is to be a felon. So, not the best agent. You want someone reliable, but you also need to tell him. Fortunately, my aunt never told her son that he was going to be her agent, so it wasn't really an issue. You have to inform and get the consent of your agent to be an agent. Now, what do you do with your power of attorney once you have it? You keep it in a safe place, but one that's accessible. You also give it to your agent or agents. You can give it to institutions, you can give it to your doctor, you can give it to your banker. That's fine. It's more important that your agent have access to the power of attorney. And why is that? Well, you can have people do things for you all the time. Lots of people have informal agents. The point of a power of attorney is that it gives your agent a legal status. If your agent goes to a bank to take out a withdrawal in your name, your bank's going to say you're not the principal. Who are you? Your agent can then produce a copy of this document and say, I am authorized to make this transaction. Now, a good bank will probably double check and get in touch with the principal and say, hey, there's someone here claiming to be your agent. It's true, the form has your name written on it, looks like your signature, but we want to make sure that you have authorized this transaction. The point, though, is the bank can rely just on that document. And agents can do all sorts of financial things. I had a client who was moving back to Brazil and had his niece serve as his agent to sell his condo while he was already out of the country. So pretty big tasks. As I said, it's effective when you sign it, unless you choose to make a springing power of attorney. Most people don't. It remains in effect throughout your lifetime. It ends with your death. This probably makes sense. But just keep that in mind. There is no effective agent under a power of attorney after you die. You can revoke a power of attorney. We do have forms to do it. It's not really necessary to have a form. If you do a second power of attorney, that will automatically supersede a previous one. But if you do want to make it clear that you've revoked it, it's not a bad idea to do a form with us. And yes, you can change the power of attorney as anytime you want. You can drop an agent and bring in a new agent. What an agent can do. Keep in mind, a general durable power of attorney is about financial matters. So, your agent can take care of real property, stocks and bonds, as you see here, business operations, claims and legal litigation, government benefits, your retirement plan, your taxes and gifts. Under the general durable power of attorney, your agent does not make medical decisions for you. Anything that, as it says here, that is not in the best interest of the principal, your agent is precluded from doing any act that is not in your interest. That's fundamental to the basic concept of agency. Your agent is always acting in your interest. Now, medical power of attorney, or what we also call healthcare power of attorney, is very different. Oh, sorry, I didn't mean to do that. I don't know how to go back. Yeah. Okay. Medical power of attorney is only about healthcare. So while the general durable power of attorney, even though the name is long and cumbersome, is just about financial matters, medical power of attorney is just about medical matters. And it kicks in a very different way. Your agent with a medical power of attorney will be communicating what is in your best interest when you are unable to do so. So while with a general durable power of attorney, your agent is acting while you're conscious or not, in medical power of attorney, your agent is acting only when you are not conscious or otherwise incapable of making a good decision on your own behalf about your medical care. As it says here, if you're unable to understand the nature or the consequences of your healthcare decision, or you're unable to make a rational evaluation of the risks and benefits of a healthcare procedure, or you're unable to communicate, that's when your agent kicks in. Now, the medical power of attorney becomes technically effective again as soon as you sign it. But your agent, under the medical power of attorney, only acts if you happen to be temporarily incapable of making medical decisions on your own. Again, it's valid only as long as you're alive, and it ends with your death or revocation. Now, who's to say that you're incapable of making a decision? Well, it's not up to your agent. An attending doctor and a secondary doctor or psychologist, that is, two people who are qualified, have to make the decision. It has to be in writing. And only then can your agent start to act on your behalf. So first the doctor says, well, so and so is unconscious or is in some way unable to function and think rationally. And then the agent, after that's put in writing, says, okay, well, here's what I think we need to do for the principal. So your agent communicates and it says your medical wishes. Well, but you're not able to express those wishes. That's what it means to be an agent under medical power of attorney. Your agent needs to know beforehand, needs to be someone who you know understands what you would want as medical treatment. Your agent will certainly listen to the recommendations of physicians. So your agent, in essence, is making those medical decisions that are best in your best interest and that you would make for yourself where you had you the capacity to do so. So your agent can look in your medical records, can hire medical providers, or refuse medical treatment, but only so long as it is in your interest, not what the agent might want, but in your best medical interest. So the physicians who are treating you would then turn to your agent and say, okay, what do we do next? And your agent could say, well, I think you should be admitted to a hospital. And the physician say, okay, we propose doing X procedure. And your agent would say, well, tell me more about that procedure, the risks and the benefits and the alternatives. And then your agent authorizes the doctors to proceed in a way that is in your best interest. Advanced medical directives. We also call them healthcare directives. That's our fourth document that we generally do. This just gives some details about them, but the main point is a healthcare declaration is what we call a living will. It is not a will, but it does have to do with end of life. And healthcare declarations is a statement, a legal statement. And again, we have draft language, we have a template, but we can modify as you wish, that says, see the second sentence, you don't want any extraordinary life-sustaining measures that are keeping you alive only because they're being applied. So people are often scared of the idea of a healthcare declaration. Again, there's no agent. It's simply your statement written out beforehand that informs anyone who encounters you or is treating you. This is what I no longer want. If I reach a point where my body is being kept alive only due to external artificial means, and then I don't want those means to continue. It's not a matter of being put to death. Rather, the healthcare declarations kicks in only when I am not going to survive otherwise, except for these artificial means. And I'm saying with my healthcare declaration, I don't want these means. So the third paragraph, a life-sustaining measure, any medical procedure or treatment which utilizes artificial means to sustain vital functions or otherwise affords a patient who has no reasonable expectation of recovery from a terminal condition and only prolongs the dying process. That's when the healthcare declaration activates. It's your statement of last wishes to medical personnel. As it says here, it allows you to avoid extraordinary life-sustaining measures that would only prolong the natural dying process. The healthcare declaration lists, but it's not an exclusive list, pretty much what you see here: artificial respiration, resuscitation, nutrition, hydration, medication, all means that are artificial and that are just and that you're dependent on to stay alive physically. Now, you can also pick. Some people may say, well, I want to continue to be hydrated artificially, but I don't want artificial nutrition. I don't want to be attached to some machine that's keeping my heart pumping if it otherwise wouldn't function, but I do want hydration. You're going to see in the slide, but I emphasize that this has nothing to do with pain abatement. The healthcare declaration does not address anything about pain abatement. You will continue to receive medication to reduce pain. This is simply about, in a sense, artificial sustaining of life. It becomes effective only if you, like the help medical power of attorney, are unable to state your own preferences and you have a terminal condition, or as it says, a persistent vegetative state. That is, you're not going to recover your mental capacity. And again, a licensed physician and a secondary physician or a psychologist has to make that determination. When is your healthcare declaration valid? When does it kick in? If you're in a position to say well, let me do that back up. You are writing this while you're fully conscious and capable. The question is, when is somebody going to look at the healthcare declaration? When is the doctor going to look at it and say, okay, this now applies? It's when you have been determined by your physicians as no longer being capable of making a decision on your own. And the physicians are therefore wondering, what do we do? It's different from a medical power of attorney because there you have an agent who is saying, I want this medical treatment to be applied. In the case of a healthcare declaration, it's your statement that you don't want artificial medical treatment to be applied if it's only serving to keep your body alive. Your agent is now out of the picture, has nothing to do with care and recovery. Yes, there's a healthcare directive registry. You can certainly register your healthcare declarations. It's not necessary. Again, your doctor should know where your healthcare declaration is. If you do have agents under powers of attorney, it's probably advisable for them to know where they are. Family members whom you trust should know where you've kept your healthcare declaration. And your physicians, as it says, your physician or healthcare facility, if you live, say, in a nursing home, staff who are responsible for your records should know where your healthcare declaration is. What if you don't have one? Well, again, Virginia law takes over. And Virginia law will decide who's going to be making a medical decision on your behalf if you're incapable of making one. That's true if you don't have a medical power of attorney. And that's also true if you don't have a healthcare declaration. State law will tell the doctors what they need to do. So, enough of my making declarations to all of you. I hope that wasn't too pedantic. I'm sorry I went through without taking questions, but please, by all means, ask me questions.
Okay, we've got a couple of questions. One is, what advice do you have about finding an agent for somebody who doesn't have family or close friends that they would trust to be an agent?
That's a very good and very difficult question. I once had a client who said, well, as far as I know, the county has a list of agents. No, the county does not have a list of recommended agents. That's really tough. Um, you could conceivably go to a bank and discuss having a financial agent who's on the staff of the bank. I think banks might be a little reluctant to do it, although again, a power of attorney does protect against legal liability. And I should have said that before. There's what's called I just forgot the term, sort of a fail-safe clause in all powers of attorney, which says any third party, like a bank or a doctor, who relies on representations of your agent is not therefore legally liable if, in fact, you later decide your agent screwed up or your agent did something that was maybe illegal and the bank, something for whatever reason, didn't know. So there is protection against liability. So that's why I say it's conceivable a bank would say, okay, yeah, we can have someone on our staff serve as your general durable power of attorney. That's all kind of babble on my part. Really, the best thing is just to find someone you trust. And I understand that is hard when you don't have family or close friends. Keep in mind the agent doesn't have to live in the area. Agent doesn't have to be a citizen. Agent doesn't even need to live in the country. But you do, on the other hand, want an agent who is available to you and who understands local laws to some degree. So that's a tough question. Keep in mind, as always, your agent cannot act in the agent's interest. The agent can act only in your interest. So you want someone who's trustworthy.
Which leads to the next question, which is, could an agent go in and drain my savings account without me even knowing about it?
In theory, your agent can act without checking on every act with you. If the agent can honestly say, this is what you would want done, or this is what you have told me I should continue to do regularly without checking in. If your agent does something that's illegal or against your interests, that is illegal. So your agent is liable. As they say, third parties relying on the agent may not be, unless they should have known better under the law. But your agent is certainly liable for bad acts. Um, it's not inconceivable to be sort of circumlocucious. It's not inconceivable, but you could have an agent who acts against your interests. Be careful whom you check, or whom you name as an agent. You do have legal recourse. The power of attorney does not protect the agent who's acted against your interests. And the court, is going to say, well, look, the agent emptied out your bank account and that money didn't go back to you. There's no question that that agent acted illegally. So it isn't necessarily a difficult thing for the court to get its mind around. It's conceivable, but as I say, get someone who's trustworthy. Generally, you should have an agent who is discussing with you what the agent is doing. That is,
Okay,
agents should check with you.
all right. Next question. Their local bank or credit union offers a service to help with wills and trusts. How reliable are those services and how much do they generally cost?
Those are good questions, and I'm not really familiar with them. As I say, a will can turn out to be pretty expensive, shockingly expensive, given that it's often a simple document. Powers of attorney tend to be cheaper. As far as services offered by banks, I don't know. It's also true that you can get or formulate wills online and just copy them and fill them out yourself. They aren't necessarily illegitimate, but they may not necessarily be legitimate. I mean, each state has its own restrictions on wills. So I encourage you to get a lawyer if you're doing a will or even a power of attorney. Um, don't just fill something out you find online. They may be good, but they may not be. As I say, our services are free, and I can't comment on what banks or credit unions offer as services.
Okay, the next question says, do we have any idea how often a medical power of attorney or a living will needs to be utilized in, for example, a hospitalized patient that the Virginia Hospital Center. Is it something that is invoked once and that's it, or does it have to be invoked regularly?
Well, they're two different documents, remember. So the healthcare or the Advanced Medical Directive or Healthcare Declaration, different names, same thing. That's an end of life document. That's only going to be unless you miraculously recover against all um, medical prognoses. That's a final document. As they say, it applies only if you're being kept alive artificially, through artificial means. And it only kicks in if you're not in a conscious state to approve the treatment that you're getting. So that's a one-time document. The medical power of attorney is different. And I can't tell you how often it's used. It doesn't even necessarily get used in the hospital. I mean, if you are suddenly fall unconscious at home or even on the street, that's when, you know, you would have to be treated. And that's when a physician or two physicians would determine this person is not in a condition to make, is not conscious or is not in a condition to make decisions. So an agent, let's go look for an agent. So it really depends. I mean, power of attorney could be used more than once. Your agent, is there to help out whenever it's necessary.
Can you talk a little bit about the relative pluses and minuses of a trust versus a will?
I don't know that it's verses. We don't do trusts. We can help you find lawyers who do, not individual lawyers necessarily, although there are some I think colleagues know well. Um, we don't do trusts, as I say. A trust is sort of a supplement to a will. And you can set up a trust, obviously, well before you set up a will. It's simply you're putting some finances aside for a particular beneficiary under particular conditions, and then your will can refer to that trust. And your will can say, okay, I've set up a trust for my children. It becomes active when they reach a certain age if I'm no longer alive. Um, But as they say, it's not either or. You can have a will that simply gives your property away upon your death, or you could have property that's stored in a trust and then the will indicates the trust document indicates when it goes into effect, but of course it's tied to after your death. One thing I meant to mention, in Virginia, if you have a lot of individual pieces of property and you want to give that, even if it's financial assets, but it's particularly true if you have particular objects that you want to distribute, art pieces or something like that, or collections. And you want certain people to get certain things. It may be easier just to make a list and then have the will refer to the list. The advantage of that procedure is if you were to name each object and each recipient in your will, and then you decide to change any of it, you have to change your will. Whereas if you have a list that's not part of the will but is simply referred to in the will, you can change that list at any time. You're giving your 67 Chevy to one cousin and then you decide, no, I'm going to give it to another cousin. If you have that on the list and the will simply refers to the list, you can change the list and you don't have to modify the will.
Would that list have to be notarized or
No,
registered?
no. It's a good question. It doesn't have to be notarized. You should keep it with the will, but only the will has to be notarized. I mean, it's true there are questions, I suppose, about a false list, but I've not encountered any state regulations about what is required of the list itself.
Okay, is there an income qualification to use your legal services?
There is if you're under 60. If you're over 60, there isn't. If you're over 60, and you have millions of dollars, we will probably encourage you to look for a private attorney just because we have a large caseload and there are not a lot of us. But no, for someone who's over 60, there are no income requirements.
Okay.
Again, you can do these documents before you're 60, obviously.
Mhm. Well, does anybody else have any additional questions?
So again, we are Legal Services of Northern Virginia. You can find our website, and through our website, you can find our intake contact information if you wanted to get in touch with us and start on the process. Um, Let me give you our main number. The main phone number is 703-778-6800. And that's just for intake. And as I say, you go through intake to see if you're qualified for our services by income or age. And then you would end up, if you're in Arlington, talking to me. If you're in Alexandria, Prince Loudoun, Fairfax, uh, you end up talking to another LS&B lawyer.
So
And
what are
if you
the
just want to consult, I mean, I guess formally, we say, well, we set up appointments for people who are really interested in going through with the documents. I'm a little more relaxed about it. If you're wondering about whether to go through the to draft the documents, but you haven't yet decided, it's fine if you call us. I'm happy to talk to you about them further.
okay. So what would you say are some of the biggest mistakes you see people making when they're making their wills?
Well, certainly the one that just obviates going any further is if you don't have an executor in mind. Um, as I say, your executor is sort of the counterpart of an agent with powers of attorney. You need to have an executor, someone reliable, someone available, someone who's on the ball. Um, your executor, we don't, we try to avoid doing wills that are likely to be contentious. In fact, one reason for doing a will is sort of to put paid to any arguments in the family. Here's my will, take it or leave it. No further arguments. Your executor probably should be someone who can deal with different relatives of yours who are going to have questions and complaints, but ultimately your executive doesn't need to be a real tough person. It's a legal process. Your executor is just overseeing it. So, get someone of some substance who's reliable. That's important for the executor. Um, the same goes for agents. That's maybe the biggest problem is people just finding someone they trust to be an agent who's around. You should know that an optional clause in a will that we draft, it's up to you if you want to use it, does say that anyone who contests the will is therefore not eligible to be an heir of the will. Um, and that's not to say that that's going to eliminate all legal contestations, but it's a pretty effective clause. I mean, it pretty much says, look, this is my will, and if you're going to quibble about it, that's going to knock you out of anything that I might have given you in the will. Not a bad clause to have. Um, I think other errors, I don't know. I'd say it's probably more of an error not to have powers of attorney and not to have wills. I have seen people pick as agents folk who aren't, as they say, around because they feel they should name a nephew or a niece or something like that. No, just get someone who is reliable and available to be your agent.
Okay. Can you send us a copy of your slides?
I can send you the slides. As I say, I also have the documents themselves, although I prefer to instead of just having them floating around. If we're working together, I will give you copies of the actual documents, but I'm happy to
Hmm.
send you the slides after this. Yes.
Yeah, we that way we can have them in the office for anybody that wasn't able to watch this morning.
So again, if you have questions, I mean, technically, you should go through intake, so our intake process can determine whether you're qualified as a client. But if you're thinking about the process and just have a question, it's okay to get in touch with me. I think you have my contact email information. I mean, I'm not going to be able to give you legal advice unless you've gone through intake. But if you
Hmm.
have a general question, I'd be happy to answer it.
All right. Well, with that, we're almost to 11 o'clock. So, time for one last question if anybody's got one. Otherwise, I want to thank you for your time. This was very clear and very understandable. So, I think for me, it was a very valuable thing to hear.
I'm happy to do it. So anytime in the future, if you want a similar presentation, by all means. I mean, I'm happy to do it any time of day or on weekends, whatever is convenient for folk. I mean, 4 a.m. is a little rough, but generally, yeah, happy to do it.
All right. Well, with that, I'm going to stop the recording.